Welcome back to Good Law, Bad Law. On today's episode, we're talking about physician-assisted aid in dying. New Jersey and Maine are set to become the 8th and 9th states, along with the District of Columbia, that have laws on the books that allow a physician to assist a patient by providing end-of-life medication under certain fairly rigid and defined circumstances. But nonetheless, 70 million Americans in a matter of a few weeks will live in a state where there is the availability to have a physician assist with dying when a patient faces a terminal illness. To help us understand the very complex and interesting, challenging legal and medical ethics issues is my guest, Emily Largent. She's a professor of medical ethics and health policy at the University of Pennsylvania in Philadelphia. Stay tuned for a really important and fascinating conversation. On today's episode of Good Law, Bad Law, we're talking about aid in dying. In a new law in 2 states, Maine and New Jersey, that are soon to go into effect, that will allow individuals under carefully scripted rules and requirements to aid in their own death. And we probably all have still images of Dr. Kevorkian from many years ago, sometimes was called Dr. Death, but it's a lot more complicated than that. And to help us understand the complex issues involved, the legal ethics and the biomedical ethical issues, is my guest today, Emily Largent. Emily, thank you so much for being on the program.
It's really my pleasure to be here.
Emily, you have a stellar background, perfect for taking on these issues with us today. Graduate of Harvard University with a degree in health policy and ethics, Harvard Law School, the University of Pennsylvania School of Nursing, and Georgetown University School of Foreign Service. I guess that last one is the one that I don't know how that fits in, but you'll help us understand that. Tell us a little bit about your own background and how you came to this subject of medical ethics generally.
Sure. Well, to start with the Georgetown degree, that was in Foreign Service, but my specialty area was health policy there as well. So that's been a through line. I think that my interest in aid in dying really came to the fore when I was working as a nurse in a cardiothoracic ICU, and a lot of the patients that I was working with there, unfortunately, they were critically ill and ended up confronting a lot of issues around the end of life and how people preferred to die. So over time, through my nursing and then subsequently through law school and also my PhD program in health policy, it's been an issue I've continued to be drawn to, just trying to understand how we should think about sort of the limits at the end of life in terms of what people can do and whether or not they should be able to hasten their own death if that's something they would like to do.
Well, let's get into this. It is very complex, and again, I think probably many people have misconceptions about what aid in dying or doctor-assisted suicide, as it sometimes is called, what it really involves. We know now that 2 states have joined the ranks of those states. I think Oregon was the first that allow or will allow aid in dying. New Jersey is set to have their law go into effect, I think, by the end of the summer, and then Maine will become the 9th state to allow people to assist in their own death, such that something like 1/4 of our country's population, some 70 million people, by the time those 2 state laws go into effect, will live in states where there is this option under under very carefully framed sets of circumstances, can assist in their own death. So maybe you could give us a lay of the land and the landscape with regard to this, how this got started and where we are today when it comes to these state laws.
Sure. So as you said, it's 9 states and then also Washington, D.C. And it is a really striking statistic, and I think bears repeating, that by the end of this year, about 1/4 of Americans will have access to aid in dying if that's something that they would like to have. So the idea behind aid in dying or death with dignity or physician-assisted suicide or physician-assisted dying is that patients can voluntarily request medication to hasten their own imminent death. So most of the laws that we have in the states, it's statutes in all but Montana. Montana actually uniquely has a court decision that gave end-of-life options to citizens of that state through the state Supreme Court ruling. But they have laid out a set of criteria where individuals can choose to, again, request this medication if they are imminently dying. And so the criteria for that is that they have to have capacity, so people need to be competent to ask for the medication, and then they have to have a terminal diagnosis with a clinician saying they have less than 6 months to live. So the laws and details vary state to state, but generally individuals have to put in at least 2 requests orally to have the medication prescribed to them, and also a request in writing. They typically need to see 2 different physicians who will both certify that they have capacity and have less than 6 months to live. And then there's a waiting period. And that waiting period, there's sort of the waiting period once you make the appointment to get there. There's the waiting period between the requests. You can't make the request simultaneously. And then there's a waiting period to get the prescription. And then in some states, there's also a mandated mental health consult. So the hope is that you don't have people who are simply depressed or are so despairing about their terminal diagnosis that they're seeing this out due to a mental health issue. And so you can have a clinician see the person to make sure that they understand and are doing this sort of, or motivated by what we think of as the right reasons, which generally relate to a desire to preserve their dignity, to have autonomy, and to control what happens to them at the end of their life.
So that last criteria that you mentioned, the mental health consultation that some states have, that seems to be a pretty important distinction. There was a much talked about case not that long ago, maybe a few weeks to a couple of months ago, involving a young woman who I believe was still a teenager, who was allowed in the Netherlands to take her own life with the assistance of medication provided by a physician. And it was I think, talked about in that it was controversial, because she was a minor still, if indeed she was under the age of 18. We'll get to that point in a second. But also the reason that she wanted to end her own life was because of mental health issues that she had. She was very depressed. I believe she had experienced some sexual assault earlier in her life and it really struggled with a lot of pain and suffering through her still young life, and that is a very different kind of situation than would probably pass muster under the laws that we have in the varying states that now allow this. Is that right?
Definitely correct in that respect. So all of the laws in the United States require that people are over the age of 18 years, so we wouldn't have minors who would be accessing this. And similarly, yes, I mean, my understanding is there's actually some misreporting. People who are advocates of aid in dying tended to be pretty upset with how that was reported, because there had been a sense that she had been given access to euthanasia when that wasn't actually correct in the details. But we also, none of our statutes in the United States would allow for somebody to access aid in dying for mental health reasons.
Severe depression or something like that.
Right.
Yeah. And I read the terms of the Maine law that was passed and that's going to go into effect later this year, and it strikes me that it's very similar to other aid in dying statutes that I've looked at, in that in addition to the requirements that you've pointed out, that you have to be a competent adult, you have to be over the age of 18, and you have to have a terminal illness, right? That there has to be a medical determination that, in the opinion of a physician, confirmed by a second physician, and I believe in most cases, if not all of the cases, that you are likely to die anyway within 6 months. How important is that feature of these laws?
So I think it's intended to really be a protection to make sure that individuals are already imminently dying, so that we are not sort of intervening and effectively killing people who otherwise would not be dying. So the hope is that you're basically giving them a chance to control the circumstances under which they're dying, but we think that this might be ethically acceptable because death was already occurring. So there are people who take very different views on whether withdrawing care, for example, versus giving somebody a medication, whether that's actually a meaningful distinction. Some people say no, it's not morally or practically a meaningful distinction between giving somebody a prescription and withdrawing care, so food, nutrition, hydration, a ventilator. Other people think that's very important. But I think in these last 6 months, people start to feel more comfortable that we are sort of providing comfort care as individuals are already moving toward an inevitable end.
Well, from a ethics perspective, from a bio or medical ethics perspective, what is wrong with somebody deciding for their own reasons that they wish to end their life? I mean, I think there's a real stigma around suicide, of course, but where someone may have, a medical condition, even if it doesn't perhaps fit into these requirements that states are imposing. From an ethics standpoint, what is the issue with individuals determining for themselves how they may end their life?
Yeah, so individuals, scholars have a number of different opinions on this. Some of the arguments against widening the criteria and allowing more people in, some people feel like it's just incompatible with traditional role as a physician as a healer, that to give the physician the ability to help somebody who is, if not completely healthy, as we might understand that, certainly alive and surviving, to give them a prescription to help end their life, that sort of goes against the norms of doing no harm and helping people. Some people, of course, have a very strong feeling about the sanctity of life and simply feel that it's wrong to hasten your own death before it's your time to go. Often, of course, that's steeped in a religious belief as well, that you should allow God to choose for you, or you should sort of live to your natural end. And people feel like the state has an interest in protecting the sanctity of life, of course. I mean, I'm sure that your listeners are very familiar with the arguments around, say, abortion or other ways in which we think that the state might be responsible for protecting sanctity of life. There are also a lot of concerns, particularly in the case of, say, people with disabilities, that there might be abuse of vulnerable populations. And so you might think that somebody with a disability would be told that they were a burden on their family, that it was a financially difficult thing to continue to care for them, just physically and emotionally difficult for a caregiver who experiences the burden, and then they might be coerced or otherwise pointed toward aid in dying in a way that we would find discriminatory and very problematic. And so the idea here is that it's a slippery slope to make these things available, and so it's better perhaps just not to offer physician-assisted suicide rather than to have the possibility that people who are elderly or disabled would experience that kind of discrimination. It's not just the abuse piece, but there's also some concern that there's just prejudice on the part of healthcare providers. So there's good empirical evidence, for example, that clinicians tend to think about the quality of life with people with severe disabilities as even lower than the general public does, despite evidence showing that people with disabilities are generally quite happy with their quality of life. So there's a bit of a paradox there, but the concern is that if clinicians have some of these biases that we know exist, it's not speculative, that this prejudice could also drive them to be more open to, willing to provide, or to educate certain populations about the availability of aid in dying as compared to others. And we worry about that kind of discrimination being baked into the system. So those are some of the arguments against it, and certainly I think expanding it even beyond the 6 months, competent adults.
My wife and I were watching a show last night, and the subject of the show was a young guy who had been shot and was paralyzed from the waist down, and how he had not only overcome the enormous challenges of that disability of being, a young guy in his early 20s now paralyzed and severely disabled from that, but how his whole outlook on life changed as he really came to grips, and how the way he would describe it, how he became a better person, a stronger person, a more fulfilled person, even with all of what he was dealing with. But not everybody has that experience, obviously, and some may suffer a terrible injury and be fully competent mentally, but that clearly that type of person who says, I don't want to live this way, I don't want to live my life with a brain injury, or with as a quadriplegic, or some horrible very disabling injury. But those people clearly would not be covered by any of these state laws, because those don't represent terminal illnesses, even if they represent a very dramatic change in their life circumstances, right?
That's right. So they still might be able to refuse care that they don't want. Obviously the law says that people have a right to refuse unwanted medical care, and it's battery to continue providing it if they don't want it. And so they might have the ability to say, turn off a ventilator, to refuse artificial nutrition and hydration. I think the group for whom it's most difficult is when there's nothing that we can actively withdraw to hasten death, which would be recognized under the law, and they don't have access to aid in dying. And so there's a group left that has few options if they're interested in ending their own life.
Right. Now, the waiting period requirement also seems to me to be so important to the way these laws are structured. I know I sat with a very close family member who had undergone a very serious surgery, and I was sitting there with him the day after this surgery, and he was afraid, and he was upset and fearing for his life. In that moment, thought he wasn't going to make it. And we talked about this topic, what do you do and how would you go about doing it? And I think it was mostly fear, because he did come through and he's lived a number of years since then. So the fears were real and valid, but from a ending your life point of view, the 15-day waiting period, which gives you a chance to, and gives the medical provider a chance to reassess after a period of time, allows for people to make less emotional decisions about this sort of thing. Is that basically right?
Yeah, you don't want anybody to sort of capriciously decide that they're interested in ending their own life when maybe with some time and reflection they would decide that they were interested in continuing at least a little longer.
So we have already, it's interesting that ever since the days of Dr. Kevorkian, when I think for most of us this issue first, became something we even thought about, this seems like something that is still so controversial. And even in Maine, where this law passed and where it soon will go into effect, it didn't pass by much in the state legislature. It passed in the House by a vote of 73 to 72, and in the Maine Senate by 19 to 16. So there was, as it's been reported, some bipartisan support for this, but the vote was still close. Why? We have other ways that people can make individual determinations. You touched on this earlier. You can go into a hospital and have in hand a do not resuscitate order, for example, which is a kind of self-determination in terms of how your life will end, where you can refuse extraordinary measures should you need to be resuscitated, for example, or refuse to be put on life support should you be in a position. As a nurse, I'm sure you saw that many times. That's fairly standard, I think, in every hospital in America where a patient can have a DNR. How, from what you've seen and from your research on the subject from an ethics point of view, but also from what you've seen, in the trenches, so to speak, working as a nurse with critically ill patients, How is this different? How is physician aid in dying different from, say, DNRs, which I think most people regard as not nearly as controversial?
Yes, I would agree with that. So I don't think we can have any conversation about aid in dying laws without really thinking about advanced directives and other ways that people can state their end of life wishes. So, whether that advance directive is a living will where people specify things that they would or would not like to have happen to them, sort of expressing it in terms of their values and their interests, or whether it's appointing an authorized decision maker through a power of attorney who can make those decisions for them should they become incapacitated. Those are very important tools for people. And then I think DNRs, which would be not wanting to have, say, CPR or any sort of resuscitation, and then also you could have a DNI, so not having any artificial ventilation. These are different ways people can control the end of life. But to a large extent, what that's still doing is saying whether or not you would like to have certain kinds of care. And so if we think about this as a decision tree, people could pursue a more aggressive or a less aggressive course of care. But at bottom, you still are letting the disease or the condition take its course. And so having aid in dying is really supposed to give families control and dignity and peace of mind by letting them choose when they have had enough or feel like it's no longer consistent with their interests to live sort of quote unquote like this.
Well, let me throw something out that I think raises some of the a different but related set of ethics issues here. Maybe not a very popular subject, and so a bit reluctant even to raise it, but I think it's real, and I'm sure you saw this too in working as a nurse with critically ill patients. But there is a significant cost associated with end of life care, and we live in a society where the cost of medical care is enormous in our country, and I don't know the statistics offhand, but I do know that an enormous amount of healthcare dollars are spent on end-of-life care on patients who probably, that care is not ultimately going to be successful. Patients who undergo surgeries or procedures, often invasive procedures, where there's very little realistic prospect of that patient surviving with any meaningful quality of life. How does that play into this discussion, do you think?
Well, you're right that end-of-life care is incredibly expensive, and there are great statistics about just how much money is spent in the last 6 months of life for a lot of, say, Medicare beneficiaries. We know those numbers are very high. I think some of that it's important to just offer as a disclaimer that it's hard to know when somebody has 6 months or less to live, and oftentimes heading into that 6-month window, I don't think either the patient or the clinicians taking care of them would have said, this is it, this is spending in the last 6 months of life, and then they pursue aggressive care. Rather, they still think that there's a chance of cure or meaningful benefit from interventions, and they pursue that, and it doesn't always end the way people would like for it to.
Well, the Maine law that I read talks about the request for assistance from a physician coming from the patient. Is there a different set of issues or concerns where the suggestion that a physician could aid in dying if these other conditions are met, a competent adult, terminal illness, and so on, and all the documentation requirements there are? Is there a different set of issues ethically where the situation comes about because the physician or some other healthcare provider suggests this to a patient?
Well, on the one hand, we think that clinicians should really set out the range of options that are available to patients when they're making decisions about a course of treatment, and then sort of in consultation, the clinician and the patient can make a determination about what's most consistent with the values and interests of the patient. At the same time, I think suggesting hastening death leads us back to those issues I highlighted earlier in terms of it being perhaps incompatible with the role of traditional medical ethics to offer to help somebody end their life when the goal is actually typically thought of as to benefit them through healing and helping. And also these concerns about prejudice against certain populations. And, I don't think clinicians are in most instances, deliberately discriminating, but you can imagine that there could be concerns that they might have implicit biases or suggest in situations where we would be worried then about discrimination against certain populations.
But the issue of how we look at death and how we think about death and what is ethical in terms of end of life care. I mean, you could also imagine, because healthcare providers, after all, are human beings and come from all kinds of different backgrounds, religiously, culturally, educationally, and so on. You can imagine that some healthcare providers would regard aid in dying for a patient who meets the criteria set out in these laws. A second physician has to confirm the diagnosis, mental health checks in some situations, being a competent adult, the patient facing a terminal, all of the requirements being met. You can imagine there are some who, because of the way they think about what death is, and how they've seen the way someone can suffer by having their life prolonged, you could see some actually wanting to counsel patients on this option as a real alternative. Do you see that as something that could, or either has already taken hold in some places or could take hold in more places as more states join in having these kinds of laws?
Yeah, I think going back to the analogy to abortion that we drew a little bit earlier, you see a divide, and there are some clinicians who are opposed to this on grounds of conscience, and states have tried to say that that's fine, that people who do not believe this is consistent with their morals or their professional role don't have to participate in aid in dying. And at the same time, there is a group of clinicians who feel very strongly that it's a reasonable part of their practice, that it would be consistent with the standards that they hold themselves to help alleviate pain and suffering for patients who have terminal diagnoses, and that if the law was different, that they would go ahead and do that they would be comfortable assisting patients in ending their own life, or in some cases even they go on and say that they would be comfortable with assisting with euthanasia, which would be the act of killing, not just giving somebody a medication and letting them take it when they're ready, but actually administering the medication yourself as the clinician. And so, yeah, there are definitely groups of people who strongly advocate against this, not just against it on moral grounds. We have those people, but for it on moral grounds, that this is an important part of their professional responsibility to offer a full suite of services to patients, and in some cases, the appropriate service is to offer a prescription and assist in dying.
Do you think that we should be? What is the conversation about dying with dignity or dying in a way that navigates through these complicated ethical issues? What is the conversation you think we ought to be having more on this subject as a country, or what do you think the points are that we should be really thinking about on the subject that perhaps we're not focusing on as much as we should be?
Well, I think that in many things in medical ethics, we need to just have a certain amount of humility about what's actually possible to achieve. And we need to recognize that people have many different interests at the end of life. I can think of patients who very vividly wanted everything to be done for them up until the last minute, and that was very important to them. And then there were the patients who had a much more, they were much more reticent to receive intensive care at the end of their lives and preferred to have less. And so they're difficult conversations to have with people about their values at the end of life, but really skilled clinicians that I've watched are able to elicit those values and interests and then help people understand how care that's being offered to them either helps or hinders in achieving those values and interests. And I suspect that people would often choose less aggressive end-of-life care if there were more frank discussions about what's really achievable, and also with offering it framed in light of the patient's values and interests. But they're difficult conversations to talk with people about dying. As your family member, who fortunately survived the surgery, but there's a lot of fear, anxiety, and you have to be comfortable sitting with the patient and really listening and validating those concerns. And those are hard conversations, and I've been really gratified to see that, great efforts are being made to try to help physicians in training with understanding these conversations, to have them role modeled for them, but they're still hard, and I think that this is a big piece of what we need is more patient education and then engagement around the difficult conversations. I mean, right now, we talked about advanced directives, and only about a third of Americans even have one.
I was just going to say, and I know this from my own 2 decades of, working with people and families in difficult circumstances, how difficult it is even to get somebody to focus on having a will, on having an advance directive, or naming somebody to be in charge of healthcare decisions. If you have, there are simple documents that can be created very inexpensively for people so that they can have decision-making authority and not have that decision-making authority taken away from them if they are ever in a difficult circumstance. And yet so many people have such a hard time even having that conversation. So do you think that as more states have joined and now allow this, and more physicians are going to confront these kinds of situations, that perhaps just in the way that you might counsel somebody to plan for a will long before you become terminally ill, let's say, you might also see more conversation on this topic? How would you, how would you face this type of decision if you were in the position where you met the criteria of these laws? You have to have a terminal illness and so on. Could you see us as a people starting to have that conversation earlier in time?
Well, I think there are important conversations. I mean, since 1990, we've had the Patient SelfDetermination Act, which is a federal law that requires most healthcare institutions to give patients a written summary of their healthcare decision-making rights under state law. So most of us who have ever checked into a hospital for whatever reason have been given this information, for example. And this was passed by Congress as a direct response to the Cruzan case, which left it to states to set evidentiary standards for the end-of-life decision-making. So after this, states went out and sort of created their own laws governing advanced directives, and it's an interesting quilt, as with all things in federalism. We see a variety of different approaches to it. But despite having this information out there now for decades, we still don't see great uptake. So I would hope that as there's a rise in people having control and dignity at the end of life, that we would also supplement that with just general decision making. So not requiring people to take any active steps to hasten their death, but really just to say, if I'm dying, this is what I would like. And that's helpful for clinicians, that's helpful for the patients themselves, and it's helpful for family members. These are really difficult conversations. When family members are put in charge of decision-making for somebody who's no longer capacitated, they really struggle with knowing how to make these decisions. They carry a lot of weight and responsibility. There have been some good studies that show that surrogate decision makers can even have PTSD after making these difficult decisions. It can create a lot of strife within families, and so we have every reason to try to have these tools at our disposal. And so the fact that there's only about a third of Americans who use them is really a shame.
Well, when it comes to aid in dying, and again, just to put this number out there, because it's striking, and I had no idea that it was as widely available as it is. But now in, is it 9 states and the District of Columbia?
Mm-hmm.
9 states in the District of Columbia, 70 million Americans now live in a state where aid in dying is available if the conditions are met. Do you see that expanding further, or what is the trend on
Yeah,
this
I
issue?
think it will. About 18 additional states right now are considering death with dignity just this year, so in this legislative session. So a lot of states are toying with the idea, and they're not all states. Some of them are deep red states. It's not just the states that you might think of as being very liberal and more open to this. In fact, it's a variety of different states have, it's come to the fore for them to start to address these questions. So I think we are seeing it's pretty rapid movement too. I mean, cruise ban was back in 1990, and so since then, 94 is when Oregon first introduced its death with dignity law. This is all pretty rapid change, I think, in the arc of history.
Well, we'll appreciate you helping us understand this better. Emily Largent, a professor of medical ethics and health policy at the University of Pennsylvania, my alma mater, here in Philadelphia, and want to thank you very much for being on Good Law, Bad Law. It's such a great topic and an important conversation. I agree we should be having more and more husbands and wives, children and their adult parents, parents and their children. This is something as difficult as it is, we should be talking about and thinking about before we get into a situation where it becomes more of a pressing reality. So appreciate you being on the podcast. Thank you so much.
My pleasure. Thank you.